Good afternoon, friends. Let us solve one more question, which is in the advocate on record examination. The question is Article 132, 133, and 134 and 134A and Part 2 of the Supreme Court Rules 2013 deals with the appellate jurisdiction of the Supreme Court. Briefly explain the different types of cases where the appellate jurisdiction of the Supreme Court vests with the court and appeals can be filed before it, and also explain the requirement to be fulfilled for invoking the appellate jurisdiction of the court. So this is the question which was in the examination of 2019. So let us dive into the answer. Friends, appellate jurisdiction of the Supreme Court of India, as laid out in Article 132, 133, 134, and 134 of the Constitution, and Part 2 of the Supreme Court rules, I am going to discuss. This jurisdiction allows the Supreme Court to hear appeals from lower courts, particularly high courts. Appeals can be on constitutional, civil, or criminal matters subject to certain conditions. Now, firstly, coming to Article 132, it talks about appeals in constitutional matters. When a case involves substantial question of law as to interpretation of Constitution, the case must be decided by the High Court in civil, criminal, or other proceedings. The High Court must certify that the case involves a substantial question of constitutional law. The High Court grants a certificate of appeal under Article 134A. For example, challenge to the constitutional validity of a state or central law. Second issue is Article 133. It covers appeals in civil matters. Civil cases can be appealed to the Supreme Court if they meet certain value and legal criteria. The High Court must certify that the case involves a substantial question of law of general importance, and the question needs to be decided by the Supreme Court. Monetary limit condition was removed after the 30th Constitutional Amendment. The examples are disputes over land acquisition, property rights, contract law, with wider legal implications. Now coming to Article 134. It talks about appeals in criminal matters. It covers criminal appeals from the High Courts to the Supreme Court in three situations. If the High Court has reversed an acquittal and sentenced the accused to death, no certificate is required. If the case involves a substantial question of law, or if it is fit for appeal to the Supreme Court, the High Court must certify it under Article 134A. Friends, although there is not in this question to be answered, but there is also a special leave under Article 136. Even if the above things do not apply, the Supreme Court may grant special leave to appeal under Article 136. Friends, I am giving example, high-profile death sentence cases or important interpretation of criminal law. Article 134A, it deals with grant of certificate for appeal. This article laid down the procedure for issuing a certificate under Article 132, 133, 134. The party must apply for a certificate of appeal immediately after judgment, and the High Court must decide this application as soon as possible. Part 2 of the Supreme Court rules deals with procedure for filing appeals under Articles 132 to 134, time limit, form of petition, and documents required, certification process by the High Court. It also deals with format, fees, translation requirements, and filing timelines. So, friend, I am summarizing this case. Article 132, type of case is constitutional matters, and substantial question of constitutional with High Court certificate. 133, civil matters, substantial legal question of general importance with High Court certificate. 134, criminal matters, death sentence, that is auto appeal, no certificate required, or other criminal matters where certificate of fitness is required. 134A, it talks about certification, enables High Court to certify cases for appeal. Article 136, that is specially discretionary power of the Supreme Court, no certificate needed. So this is all about, friends, the answer to the above question. Enjoy video, solve the papers, and have a good luck.